Okay, the sheriff from Osceola County just got hit with a Rico. And I ain't gonna lie, this is the same dude that took down Stephen Stearns, and he has done a lot for his community.
Sheriff Marcos Lopez, yeah, the guy you see shaking hands at community events and talking tough on crime, just got snatched up by Homeland Security and hit with Rico charges. Investigators say he wasn't just turning a blind eye. He was the one pulling the strings behind a full-blown gambling empire. It all centers around a place called Eclipse Social Club in Kissimmee. Sounds innocent, right? Wrong. Inside, it was lit with illegal slot machines, rigged lottery games, and a money trail that ran deep. Authorities say this spot pulled in over $21 million and Lopez made sure it stayed untouched by law enforcement. On June 5th, they put the cuffs on Lopez. Sheriff turned suspect, arrested by the same system he used to run. Homeland Security led the takedown, and within hours, Governor Ron DeSantis dropped the hammer, suspending him and bringing in a new sheriff, Christopher Blackman. The feds claim Lopez was getting paid off through campaign donations and quiet personal payouts. In return, he allegedly protected the operation, warned them about upcoming raids, and helped keep the heat off. That's not sloppy police work. That's organized crime with a badge. Osceola County residents are stunned. One minute their sheriff is making Facebook videos about community safety. The next he's a headline in a federal indictment. Locals say the Fusion Club had shady vibes for years, but no one ever imagined this. Lopez pled not guilty and is sitting on a $1 million bond. His arraignment's set for June 30th, but don't expect this to die down. Feds are hinting there's more to come. More names, more arrests. This might be the first domino to fall in a way bigger Florida takedown.
Okay, this is Sheriff Lopez's first court appearance. They hit him with a $1 million bond, and they're trying to tell him, yo, you're going to have to use money that you got from being a sheriff, none of this gambling money. Now, this dude, like I said in the beginning of the video, has done a lot for his community. I mean, when it comes to the youth and when it comes to sex trafficking, he's not on the level as a Grady Judd, but he's right there. You know what I'm saying? So this is a shocker to the community.
You have the right to remain silent. Anything you say could be used against you in later proceedings. You have the right to communicate with your lawyer, with your family, and your friends. Reasonable means will be giving you the opportunity to do that. Can you raise your right hand so I can place you under oath? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do, ma'am.
Thank you. Could you tell me your name, please?
Marcos R. Lopez.
Mr. Lopez, you were here this morning in Lake County case number 2025 CF 1479. It's a warrant that was issued for you for one count of racketeering and one count of conspiracy to commit racketeering. Attorney for statewide, I believe, is here. Would you like to be heard as to the setting of bond and any bond conditions? I know you filed a motion about the source of funds today, so if you would include that in your remarks, I'd appreciate it.
Yes, Your Honor. Panayota Papakos for the Office of Statewide Prosecution. As far as conditions, the state would be seeking an electronic GPS monitor as a condition of any release. We would ask that the court order the defendant to turn over his passport to the clerk of court. We would ask that he forfeit any and all firearms in his possession. And further, Your Honor, at this time, the defendant is charged with 2 first-degree felonies. So the state would be seeking a $600,000 bond as to each count for a total of $1.2 million. And I will go into essentially the criteria that the court has previously announced. First, the nature and the circumstances of the offenses charged justify this amount of a bond in this case. The state has filed an affidavit. I believe that the clerk filed it in separate sections because it is 255 pages. And so I provided it to Your Honor's judicial assistant this morning. And just some highlights that the allegations in that affidavit, the detail an extreme breach of public trust, the circumstances surrounding.
And this is why it affects the Madeline Soto case, because you lose the trust from the whole department. Everybody, from anybody down from Lopez, the sheriffs that are going to get questioned in that, the lawyer's going to be able to eat them up.
His misuse of office as the sheriff of Osceola County are very serious. Again, there's direct evidence in that affidavit of ongoing illegal enterprise. The weight of the evidence includes that the defendant obtained between, at the very least, $600,000 to $700,000 since 2020 from this illegal enterprise in cash payments. There is evidence in the affidavit of a wire transfer to a bank account he controlled through a fictitious business name. There's direct text.
He's definitely cooked. They definitely have so much evidence, text messages, wire transfers, all that, you know what I'm saying? But the maximum of what he's facing is 55 months. So I'm thinking, and he was a former sheriff, that there's a lot of things to question how he's going to be handled in jail. I reached out to him too. I really want to get a statement from him because honestly, at the end of the day, he's done so much for that community, and this isn't a charge that is like horrible. Let's be real. He was making extra money on the side, definitely being a little bit dirty and crooked, but it's not no chomo charges or anything like that.
Message evidence from both WhatsApp and cell phone applications of his involvement in this enterprise dating back to 2019. Beginning on page 110 through page 148 of the affidavit, there are numerous text messages from the defendant directly to co-conspirators. The first co-conspirator being Miss Zhang, also goes by Kate. Those direct text messages evidence that he was using his influence as the sheriff even prior to election, indicating he was very respected in his community to facilitate the illegal enterprise. There's screenshots of slot machines and things of that nature in those text messages. Of note, I would direct the court to page 175, where the defendant was actively sourcing new locations for illegal businesses to come in from Lake County to Osceola County. That began in 2021. And then further on, beginning on page 229, there are text messages between the defendant and co-conspirator Krishna D. O'Karen. Your Honor can see some of the affidavit is redacted, but there are photos of active law enforcement officers that have responded to those locations. I'm sorry, there's some audio interference. There are photos evidencing the defendant's direct involvement and also using his influence to potentially obstruct criminal investigation into these businesses in Osceola County. So that would be the first two factors: the nature and circumstances, and then the weight of the evidence. Again, evidenced in that detailed affidavit that was completed both by HSI task officers and the Florida Department of Law Enforcement. So there was two co-affiants in that case, with the understanding that this is a joint investigation. The defendant does not have any ties to Lake County that we are aware of. He has been suspended from office by the executive order of the governor. And moving on to subsection F, the source of funds, the state has filed a motion this morning, and I've provided it to the judicial assistant in its entirety. But essentially, this is a motion where we would be asking the court to inquire into the source of any funds that the defendant would use to post bail, or that you'd be using for collateral. Essentially asking the court that prior to posting that the defendant show that these are not funds derived from any illegal enterprise or any illegal proceeds. And I would rely on the written motion essentially that the statute allows the court to conduct that inquiry. And so we would ask that any release be stayed until the defendant meets his burden of showing that those funds are from non-criminal sources.
Anything else?
Not at this time, Your Honor.
Abraham.
Your Honor, $600,000 is a very high bond for the nature of this crime. Mr. Lopez has no criminal history. He has extreme ties to the community in Osceola County, which is still within the state of Florida and not very far from Lake County. He does have a family. He was publicly elected for 2 different terms as a sheriff's office. He does have funds from working at the sheriff's office. This is a white-collar crime, a non-dangerous crime. There is no indication that Mr. Lopez would be a flight risk in any way, or that he would not attend any of his court hearings. He has employment history. He does have financial resources. He has family and friends that are supportive to him as well. We would ask that this bond be set in the amount of $25,000 in each count. As state indicated, he no longer has his position at this time, so a $600,000 bond for each count would be tantamount to no bond at this point. When speaking with his family, there was indication that $25,000 on each count would be affordable to the family. Although Mr. Lopez has a title, we would ask the court to still look at Mr. Lopez as a regular individual and not just because he has a sheriff's title that he should be treated any differently. This is a racketeering charge. These are first-degree felonies. We'd be asking that his bond be set in a reasonable amount that would be affordable to his family, and that each count would be set in the amount of $25,000. In terms of conditions, there is no indication that Mr. Lopez would be a flight risk in any way. Mr. Lopez would agree to turn in his passport. In terms of having a GPS, if Your Honor would like for him to have a curfew, I believe Mr. Lopez would comply with that. I don't see the need for a GPS. This is not a violent crime. He is not a danger to society. This is a white collar money crime at this point. GPS monitor, defense would argue, is not necessary at this time. He would comply with the conditions of no contact with any co-defendants in the case and surrendering his passports. Again, with the firearm condition, this is a non-violent crime. He's not a danger in any way. He doesn't pose a danger to the community. So we'd just be asking Your Honor to set conditions and a bond in a reasonable amount. Thank you.
Anything else?
Your Honor, briefly, we have HSI Task Force Officer Frank Tagler, as well as FDLE Inspector James Frank was on the line. There, in the course of this investigation, they determined that the defendant has traveled to Puerto Rico and there are ties to Puerto Rico. So that was the reasoning behind asking for, first of all, with the understanding that it's still the United States, we were asking for a monitor.
Anything else?
And then no contact with the co-defendants. I don't believe that I said that.
You didn't, but Ms. Ibrahim mentioned it and I had it in my notes to impose that as a condition. Anything else, Ms. Ibrahim?
Just because he has ties to Puerto Rico or that he's been to Puerto Rico still does not indicate that he would be a flight risk or not attend any of his court hearings that are required of him. So we would be arguing against the GPS monitor as a condition. In terms, and Your Honor, my apologies, in terms of the money income, he has been working at the sheriff's office, so he does have legitimate funds to be able to use to bond himself out.
All right. I am going to set bond in the amount of $500,000 on each of the 2 counts for a total of $1 million. I will require Mr. Lopez be fitted with a GPS monitor prior to his release from custody should he post the bond that I just set within 72 hours of release from custody. You'll be required to surrender your passport to the clerk's office for safekeeping, Mr. Lopez. You will be required to surrender any firearms in your possession to law enforcement. Which agency, Ms. Papakos, do you think would be most appropriate? Florida Department of Law Enforcement?
Yes, Your Honor.
That's what I assumed, to FDLE, and I will put that in my order that within 72 hours of any release from custody, all firearms in Mr. Lopez's your possession will have to be surrendered to the Florida Department of Law Enforcement. You may not have any contact whatsoever with any named co-defendant in the case, and I will make sure their names are in the order. Your next court date for right now is June the 30th, so I'm sure your attorney will be in touch with you. Anything else?
No, Your Honor.
No, Your Honor.
Is that the
Alright.
bond?
I'm sorry, somebody asked a question, I think. I'm not sure who.
How do I start the bond process?
So your attorney is likely to come talk to you in just a few minutes. She's probably going to come across the street, Mr. Lopez, and do that. If that doesn't happen, they're going to let you reach out to your family and to your friends. Also near the phones over there is a list of bail bonding agencies. You might want to try that as well. But I think your attorney is likely going to leave my office here shortly and come talk to you. So you can chat with her whenever she comes over in a few minutes.
Okay, thank you.
And Your Honor, if I may,
Certainly.
the NIMBY hearing is not necessary.
I am going to grant the state's motion as far as the source of funds goes pursuant to Florida statute 903.0462F. So the source of the funds will need to be shown to the state. If that's not satisfactory, you all will need to have a hearing in order for Judge Welke, who this case has been assigned to determine if the source of the funds has been appropriately shown. If the state agrees, you all can file a stipulation to that.
Your Honor, may
Yes,
I
Your Honor.
request that a hearing be set on Monday?
I would not have the jurisdiction in order to do that, and I do not have access to Judge Welke's calendar. You all are more than welcome to reach out to see if he can set a hearing today. I think that would be the best thing under the circumstances. I don't know what his schedule looks like, but I'm sure he'll get you hearing time as soon as he can.
Thank you, Judge.
Certainly.
That is all I have.
Anything else from the state?
No, Your Honor, I believe that there is one more co-defendant that was taken into custody, but I don't have information as to whether she's on the docket for this morning's first
I
appearances.
actually have 2 co-defendants, female on the docket who were taken into custody. In this case, Ms. Frederick, and I'm not sure how I say the last name of the other person, Cote, I believe.
Okay, so Sheriff Lopez has 4 other co-defendants, and you know they're going to be talking. So he probably is going to take a deal eventually. Now, let's not forget that he did 22 years in the military before he became a sheriff. Grady Judd puts a statement out, "I'm extremely disappointed and shocked by Sheriff Lopez's criminal conduct. He has embarrassed himself, his family, and a great men and women who work at Osceola County. His conduct is outrageous, unprofessional, and obviously corrupt. He forgot the first rule in public service. No one is above the law."
While serving as Osceola County Sheriff, Marcos Lopez sparked outrage in 2024 when he authorized the public release of a graphic crime scene photo of 13-year-old Madeline Soto, a young girl who had been brutally murdered. The image posted to the official sheriff's office Facebook page showed Madeline's body wrapped in a blanket, a move that was immediately condemned by the community, victims' rights advocates, and Soto's grieving family. Lopez later admitted to approving the post and was fined $250 for violating victim privacy laws. Though unrelated to his recent racketeering charges, the incident raised serious concerns about his judgment and ethics, foreshadowing a troubling pattern of behavior that would later become central to his fall from power.